Used, that is, other than for performance of our duties, then this double-edged sword do not cut the bad elements in the society, but it hurt us. Therefore, the topic is very important and we are supposed to use these powers with utmost care and precaution with the procedure given in section 23 and only for the performance of duties given in rule 51 and 52. As far as Tripura is concerned, rule 51 is of use and importance because I think you hardly have any drug manufacturing unit or cosmetic manufacturing unit or medical device manufacturing plant. You have the sales units and you have to ensure the quality, safety and efficacy of drugs being sold in your state or being distributed through the government set up hospitals, CHCs, PHCs, etc., or purchased by the procurement agencies through tender processes, etc., for the people living in your state. Duties of inspectors of premises licensed for sale, Rule 51. I am not going to discuss much about Rule 49 qualification of inspectors, just with one line that inspectors for sale units, we have not to read that proviso provided that he is having that much of experience of manufacturing of Schedule C and C1 drugs or testing of Schedule C and C1 drugs in the manufacturing unit licensed by the competent authority, that is state licensing authority for that purpose, and in a testing laboratory again regulated and licensed by the state licensing authority of the state, or inspection of the units indulged in the manufacturing under the supervision of some senior officer. That is silent word which is to be read along with that. Since you don't have the manufacturing units, don't go for that Rule 52. Otherwise it is generally a replica of 51. Now for the sale units. Subject to the instructions of controlling authority. Where the controlling authority is given. Rule 50. Controlling authority is there. What we mean by the word subject to the instructions of controlling authority? That is very important. No inspector has infinite power to act in his or her area of jurisdiction. He is also a controlled authority, controlled by the controlling authority or under the administrative control of administrative officers. If you are not acting as per subject to the instructions of controlling authority, what may happen? I can tell you the example. Recently, in Haryana has adopted a software called randomization of inspections or sampling. Now the inspectors in Haryana, they are not free or independent to go and conduct inspection of any sale unit in their area of jurisdiction. They are getting the names of the firms to be inspected from the headquarter, which is controlled by a software which is giving them and sending them names of few firms, and within that period of 7 days, 15 days, they are supposed to and directed to conduct inspections of only those firms which have been given by that super boss computer. To avoid such a situation to come, we must know the meaning of subject to instructions of controlling authority. If our behavior is uncontrolled and unruly, then definitely such provisions are bound to come. As in the morning session, I told you in one line that law is dynamic and law is a legal tool to resolve the problems of the society, not to create problems for the society. Therefore, subject to instructions of controlling authority is very, very important. And we should not deviate from that. Your controlling authority is very lenient. You have cordial relations with the controlling authority. But this provision is still there. What exactly this provision means? Your every action, your performance of duties is subject to the instructions. Whether it means that you have to take the prior permission for performance of every duty, or there must be some general instructions from the controlling authority or under the law for performance of your duties. Now that is to be answered. Whether you require a prior sanction, you are going for an inspection. Whether you will call your controlling authority, sir, ma'am, I am going for inspection, may I be permitted to conduct that inspection? Is that the meaning of subject to instruction of controlling authority? Then answer comes no. That is the general instructions given in statute or rules itself. What is that? Inspection of every sale unit is required to be conducted once in a year. Now what happens? The firms which are situated near to my office, I am conducting the inspection of those firms twice or thrice in a year. And firms which are situated in the areas where the transportation facilities are not available, or the person is like that, I don't want to go and conduct the inspection of that firm, then I am not conducting the inspection of those firms even once in 3 or 4 years. Then comes the subject to instructions of controlling authority, when the rule has given the mandate that the inspection of the sale unit is to be conducted once in a year. That means every firm, every sale unit, retail or wholesale, is required to be inspected once in a year. Got it? If we are not doing, then the problem of randomization may come in any of the state. Now, second thing is inspection of sale unit. You have the performer, Form 35, for inspection of the units. Whether you have reviewed that performer, whether that performer gives the complete details, what exactly is going to be checked, required to be checked by an inspector at the time of inspection. Please review that or get it reviewed taking help of any one of us. That should include every condition of license. You have to check whether that is unit, retailer or wholesaler, is making compliance of every condition of license which they are supposed to make. Number one. Number two, please remember one more section. Always remember that section. Section 2 of Drugs Act. What exactly it says? Application of other laws is not barred. Now question arises, and anyone of you may say, sir, I am only empowered to act under the Drug Act and I have to check the conditions of license given in the drug rules only. Why should I check whether he is making compliance of NDPS Act or MTP Act or Poison Act or Kotpa Act? Then read that section carefully. No law can stand alone. कोई भी कानून, ड्रग एक्ट नहीं कह रहा हूं मैं, कोई भी कानून अकेले खड़ा होकर के सरवाइव नहीं कर सकता, और ना ही कोई कानून अकेले रहता है. Every law, now this is given in the section 2, but I am making it wider. Every law, provisions of every law, is in addition to and not in derogation of any other law. I have made a general statement. It is given in section 2. And similarly, in the NDPS Act also, there is section. Which section is that? Probably section 80 is that, which very clearly says and mandate Drugs and Cosmetics Act, which again says application of other laws is not barred, and the provisions of Drugs and Cosmetics Act 1940 are applicable along with the provisions of NDPS Act. Now I am coming to the first problem which I told you that we will discuss in the morning. Medical intoxicants. What are the medical intoxicants? What we mean by the medical intoxicants? Any drug containing narcotic substances, narcotic drugs or psychotropic substances, and is capable of causing addiction to the users. The word addict is also defined under NDPS Act. When my body becomes dependent on the use of that particular substance, then I become addict to that substance. And this is the major problem, not only in Tripura but now in North India also and complete Northeast. And your problem is ahead of this. You being sharing a large porous boundary, international boundary with Bangladesh. Therefore, at the national level, it is always alleged that the codeine-based cough syrups are moving through Tripura to Bangladesh. It is alleged. You must have heard when we go through the NDPS, then we come across Golden Triangle. That Golden Triangle was initially with Afghanistan, Pakistan and India. That part of India, Punjab. But now, whenever you find in the Google, search in the Google, then this Golden Triangle is shifting from that western part of the country to the eastern part of the country. Now Myanmar, Bangladesh and Northeast India is becoming the Golden Triangle for supply chain of narcotic substances. And we have the duty. Now, only raising the problem is not my motto. My motto is to suggest certain solutions for these problems. I don't know whether you are asking for under section 18A the complete sale purchase records and reports of all these narcotic substances, medical intoxicants, drugs containing narcotic drugs and psychotropic substances. If not, then please start asking and give a standing instruction using your powers, which your licensing authority can also pass, or an inspector is also authorized to ask for such records. Whenever you purchase any medical intoxicant, you make a list of it and then give them the standing instruction. Then that report is required to be submitted. Number one. Number two, many of the states have restricted the quantity to be kept with a wholesaler or a retailer. Although these restrictions orders are challenged in various high courts, one or two high courts, I think, have stayed those orders, but for a greater cause to be addressed, I still feel with the properly drafted orders, this can still be issued, if not issued in your state. But asking for the sale and purchase record by an inspector or giving an order by the licensing authority, nobody is going to say no to you, because madam is also passing cancellation orders. People are going and challenging those in the high courts. Even after that, opportunity of personal hearing is being given and again pass the cancellation orders. That has been done by your state, and that's a big thing to be done. Then we can take that as a measure to protect not only our citizens, but becoming this as a golden triangle for the supply chain of narcotic drugs. Second, few of the drugs which are still not there in the narcotic substance, drugs or psychotropic substances. There is a difference between narcotic drugs and psychotropic substances. While taking action, always be very careful and take action accordingly. Generally, people feel that tramadol is listed in where? Narcotic drugs or psychotropic substance? We will discuss it. Anyone else? Tapentadol? That is not in the narcotic drugs still. Gabapentin? That is again nowhere. Exists nowhere. Phenramine maleate? Exists nowhere. NDPS is concerned. Then you have to use the measures given in the Drugs and Cosmetics Act to control them if they are being misused in your state for the purpose of intoxication, and send the recommendation to the DCGI as an agenda in the DCC to consider these for NDPS. But who will consider and who will take a final decision? Then Ministry of Home, Department of Revenue. Then that recommendation, after passing through, when you send the proposal, it will go to the DCC. DCC will discuss and then send it to the Department of Home. Till then, use the tools given in Drugs and Cosmetics Act. Next comes sampling for the purpose of test and analysis. Which section we use for the purpose of sampling, where the procedure of sampling is given? Section 23, where the minimum quantity of sample to be collected is given. These are given in DCGI guidelines. On the request of all the government analysts and directors RDTLs, and for proper analysis, a minimum quantity is required. Then DCGI has issued a circular for compliance to all the drug inspectors through their state drug controllers, giving the mandate of minimum quantity required for sampling. For example, I will send you that in your WhatsApp group or wherever you are comfortable to receive that, because I am not going to tell you every dosage form and then quantity required. That I will send you the list. For tablets it's 100, for capsules it's 100, but what we are doing, for 100 to be sent to government analyst along with form 18. Form 18 is memorandum to government analyst. If we are collecting the quantity less than the mandate, then the manufacturer may take a plea that this was the mandate given by the DCGI and the quantity collected for analysis is less. How they have conducted the analysis? Analysis must have been compromised. Second, minimum quantity must be collected. Section 23. Again, mandate. Give a chance to the person from whom you are collecting the sample. Form 17 is the intimation to the person from whom you are collecting the sample to add his own seal or mark on the sample. We generally, in 80 to 90% cases, are not doing this. And this is a mandate given in section 23, opening 4th or 5th line. If you have the Drug Act, if you don't have, you can take it and you can read that. Even if we are not doing it, we are not mentioning it also. Don't you think that opportunity has to be given to the person? And we must write a line, at least in compliance to this provision in the section of the Act, that he has signed each and every sample portion in lieu of his seal or mark. अगर हम नहीं लगवा रहे हैं या उसके पास सील नहीं है, तो क्या हमें ये नहीं लिखवाना चाहिए, लिखना चाहिए? Again, this is a question, matter of discussion, that Form 17 do not even have the provision of getting his signatures. But that is again there. When it says one portion of the sample is to be given to the person from whom sample is collected along with Form 17 against an acknowledgement. When it is against an acknowledgement, then you have to take the receipt of it. When we are taking receipt of it, then you can ask him to give the statement. And any statement made by the person in front of the drug inspector is admissible. That is not the police कि हमने धक्के से लिखवा लिया, पुलिस ने डंडा मारा, लिख खाली पे साइन कर. Drug inspector can't do that. Next provision. Again the line is there. One portion you have to send forthwith. 2341. The word used is forthwith to the government analyst. And in 30 to 40 and 50% cases, I am telling you, most of the inspectors, what they are doing, collecting the samples, keeping in their possession and sending it once in a month. And when we ask why you have not sent it earlier, sir, वो पैसे लगते ना रजिस्ट्री के, तो हमने इकट्ठे कर लिए, इकट्ठी रजिस्ट्री करा दी. Whether government is asking you to save a very petty amount of doing a registered post and parcel? Answer is no. You have to send forthwith. Forthwith means same day or maximum by next working day, not later than that. You are not supposed to keep the samples in your possession, that too when you have not allowed the person from whom you have collected the sample to put his own seal or mark. Then the chain of custody of sample is compromised. And then this can harm your case in the court of law. Whether we are making compliance of this provision. Then there is we have started a new thing. As soon as we are sending the samples for analysis to the government analyst, we are sending the one portion to the manufacturer. Asking the manufacturer to inform whether this drug is actually manufactured by them or not, to ensure that this is not a counterfeit drug. Is that the right thing to do? What the law says. To whom that sample portion belongs? जिसका नाम 18A में आया, name of the person, address whose name is disclosed, that I have procured or acquired or purchased this drug from such and such person, that sample portion first belongs to them. That is the provision. And now you have not completed the chain. You have just seen the label, and label it is written ABC Pharmaceuticals, Baddi, Himachal Pradesh, and you have sent the sample portion directly to ABC Pharmaceuticals Limited, Baddi. That is again not a right practice to do. You cannot jump directly to the roof. You have to go by stairs, stepwise. Complete the ladder first. Conduct the investigations. Then only do that. Otherwise, don't do that. Third, again, your problems, I am going to touch your problems only. You are sending your samples to Director RDTL Guwahati also. What is Rule 45 and 46 says? And no drug inspector is doing this. 100% non-compliance. Duties of government analyst clearly mandate that he has to furnish the test report of the sample within 60 days of receipt of sample. And the government analysts, if we go by their versions, they have the burden, too much of burden, that they are getting samples from the drug inspectors for analysis, but they don't have the workforce to analyze, they don't have the GSOs under them to work and analyze within that period, or they don't have the test procedure. They don't have the reference standards. Then the government analyst, they are asking the procedure from you people. And you people are sending those letters as received from government analyst directly to the manufacturer. Provide the sample procedure. That was discussed at Guwahati also, on the request of drug inspectors of Assam, Meghalaya and others. And then Rule 45 mandates to furnish that test report within 60 days. You are not receiving that test report. If you are not receiving the test report within 60 days, any one of us, whether issuing any reminder or letter to the government analyst to furnish that test report within that mandated period. High Court of Karnataka, in the matter of Zim Laboratories, they have given the mandate. If this compliance is not made, the entire proceedings were quashed. And DCGI, why these guidelines came into existence, I am telling you that story also. DCGI by the High Court of Karnataka was mandated to give an affidavit that in the entire country there will be a procedure to make compliance of these provisions, whatever I have discussed. Then DCGI issued the guidelines, thinking that everybody will obey that guidelines, but in maximum states they have started doing it. If you don't have those, please have it and start making compliance of it. Now the question arises whether government analyst can ask for the procedure from the manufacturer, or whether the manufacturer is bound to give the reference standards and the testing procedures. Then kindly peruse Rule 46. It is obligatory on the government analyst if a drug is non-pharmacopoeial. If a drug is pharmacopoeial, then procedure is given in the pharmacopoeia. But if a drug is non-pharmacopoeial, for that purpose you may say that drug is patent and proprietary as defined under section 3H2. In those cases, government analyst has to make his own method validated and submit the reports. उसके प्रोसीजर वो गवर्नमेंट एनालिस्ट खुद बनाएगा. क्या हम ये सोचते हैं कि जिसकी दवा है उसी से हम मेथड मांगेंगे, उसी से सैंपल मांगेंगे, फिर कहेंगे कि इसको टेस्ट कर दो, उसी के रेफरेंस स्टैंडर्ड से, उसी के टेस्ट प्रोसीजर से, फिर कहेंगे कि वो एनएसक्यू आएगा क्या? उसी का सैंपल है, उसी का स्टैंडर्ड है, उसी का मेथड है. वो कुछ भी देगा, नहीं देगा तो क्या प्रोसीजर है आपके पास? प्लीज try to go through these provisions. This is sampling. One more thing as far as sampling is concerned that I touched in the morning also, and I think that after these two sessions you must prepare your SOPs for sampling. In our state, Haryana, ACR's annual confidential reports of every field officer was linked to their performance. They were told to submit the self-appraisal reports informing how many adulterated, how many spurious, how many they have detected, how many seizures they have done, how many actions under DPCO they have intimated to NPPA or taken action through PMRUs, etc., etc. Or how many cases they have reported of MTP. In how many cases action under NDPS Act has been taken on their initiation. Not on the initiation of the police, that police have taken hold of him and then they called you, then you went there and signed. No. When you have initiated the action, please prepare SOP for that. Use the methods and means, physical methods, to detect counterfeit, spurious and adulterated drugs. Schedule H2. How many of us has ever checked the code, QR code, save the brand? Every big company, they have their logo, they have their motto. They want to save their brands from counterfeiting. They are ready to cooperate with you. But whether we are genuinely asking for their cooperation, whether we have ever scanned the QR codes, this we have to decide, and we have to make the SOP for that. And always try to detect as many as possible adulterated and spurious drugs in your area of jurisdiction. That will show the positive about you. That is not negative about you. Investigation of complaint. What is the difference between investigation and inspection? We received a complaint and we have gone through the contents of the complaint. Now we are investigating whether this complaint is true or false, whether to initiate any action on that complaint or to file saying that this is a false complaint. That is the basic difference. But in law, also there is a difference. Then institution of prosecutions, that sir will explain you. Next, 6. Record of inspection, sampling, seizure, etc. and submit to the controlling authority. Which I think, if the system is working online, then it is visible to the controlling authority, or otherwise physical copies we are not sending to the controlling authorities, and we are not making compliance of rule 51(6). What is the use of it for an inspector? Suppose an inspector has committed some mistake while making a seizure. He has not joined the 2 independent witnesses. That is mandated in the new criminal laws also. Whether we know who can be the independent witness? Can your colleague, another drug inspector of some other area who joined the inspection or investigation, signed the Form 16 seizure form, can he be considered as an independent witness? Any defense advocate will say they are from the same department. How can he be the independent? Can never be. He is part of team of inspectors. He is member of inspection team. He is not the independent witness. Same is the condition with the doctors, medical officers, government medical officers, going for the accompanying you for the investigation and joining the seizure. Independent witnesses means 2 respectable persons of the locality. If nobody is available, you are not in a position to join the independent witness, then what to do? there are ways. Then you have to write one line. Many persons gathered on the spot who were requested to join as independent witness, but they refused and not disclosed their identity. अगर आइडेंटिटी डिस्क्लोज करता है, then again you have the power to take an action against that person who is refusing to join as an independent witness. You have the power to issue order to the persons who gathered on the spot to join as an independent witness. If he refuses, then you can take or initiate action against. And the new laws, new criminal law, mandate for the videography. Be ready for that also. Be ready for that also. Inquiries and inspections and NSQ, action taken on the NSQs. Do you know what is the protocol of taking action on the NSQ drugs? Then kindly visit the CDSCO website, and again there is direction from the DCGI, instructions which is mandatory to be followed by all of us for taking action in case of NSQ drugs. A, B, C categorized. In these cases, this is mandatory to launch a prosecution. In few cases, discretion, and in few cases, it is not recommended. Please go through those, or sir will explain you. This is same prosecution. I think every inspector is taking the prior sanction before filing the prosecution in the court. When we were there in Bihar to give training, they issued some order. I don't know what was the basis of that order and what was the reason behind that order to the drug inspectors, that there is no need of asking for the prosecution sanction and they can decide at their own level. Don't you think that it is against the subject to instructions of controlling authority, and it is against the line which is mandated as duties of inspectors for institution of prosecutions? My suggestion is, when you will make the SOPs for prosecutions, then make it mandatory for obtaining prior sanction to launch the prosecution in the court. How it will protect the inspector? When you have taken the permission, then onus shifted from the shoulders of inspectors to the shoulders of controlling authority also. Otherwise, you are stand alone answerable to any further trial and comments of the court during the trial. You don't have any protection line. When you have obtained the sanction, then you have the protection that I have obtained the sanction. What is the precaution to be taken while obtaining prosecution sanction? Submit the complete list of accused persons with their role and responsibility in the commission of that offense. पूरा लिस्ट आप दे देंगे, अब उसमें से कोई घटाएंगे नहीं, बाद में कोई बढ़ाएंगे नहीं. पता लगा कि गए नहीं है कंपनी में कभी भी मैन्युफैक्चरिंग की, वहां पर इन्वेस्टिगेशन की नहीं है, मिनिस्ट्री ऑफ कॉर्पोरेट अफेयर्स या वो जो रहता है वेबसाइट उससे डाउनलोड किया और इंडिपेंडेंट डायरेक्टर्स को भी उठा करके एक्यूज बना दिया, सैंक्शन ली नहीं, कंट्रोलिंग अथॉरिटी को पता नहीं, आपने अपने लेवल पर डिसाइड कर लिया, एंड व्हेन कोर्ट विल फॉल हैवीली डाउन ऑन यू, देन यू आर नोवेयर। आपको पता ही नहीं आंसर क्या देना है इसका, आपको इंडिपेंडेंट डायरेक्टर एंड रिस्पॉन्सिबल डायरेक्टर में डिफरेंस ही नहीं मालूम है, आपने अपनी इन्वेस्टिगेशन में रोल एंड रिस्पॉन्सिबिलिटीज फिक्स ही नहीं की, दैट इज मैंडेट। पावर्स, इंस्पेक्ट एनी प्रीमाइसेस, मैन्युफैक्चरिंग और टेस्टिंग। अभी इसके ऊपर ज्यादा डिस्कशन नहीं करें क्योंकि आपके यहां है नहीं, बट यू हैव टू बी प्रिपेयर्ड फॉर दीज। अर्लियर all the medical devices were licensed under drugs. Now MDR 2017 is there. Now the licensing procedure changed. I still feel your state must be having many medical device manufacturing units coming under class A or B. That is my feeling. उसके बिना चल ही नहीं सकता. But since I don't know whether you people are notified as MDOs or not. Are you notified? Medical device officers. Morning में तो मना कर गए. नहीं, चलिए. Your lab is notified as MD, Medical Device Testing Laboratory. Your lab is accredited with the NABL. Get it done. अंडर प्रोसेस, तो उसको जल्दी करवा लें ताकि फिर ऐसा ना हो कि मेडिकल डिवाइस का सैंपल आप फॉर्म 17 पर लेकर के एज अ ड्रग ले लें और उसकी टेस्ट रिपोर्ट भी फॉर्म 13 पर आ जाए और गवर्नमेंट एनालिस्ट साइन कर दे और सारी मेहनत उल्टे आपको ही आंसरेबल बना दे कि इसका ये किया क्या आपने. वाई यू हैव नॉट कलेक्टेड द सैंपल ऑन रिक्वायर्ड एमडी फॉर्म. प्रोसीजर्स आर डिफरेंट फॉर सैंपलिंग ऑफ मेडिकल डिवाइसेस. Procedure of sending the sample to the government analyst is different, to the medical device testing laboratory is different. Format for test report is different for medical devices. Standards are definitely different. You cannot get it tested treating it as a drug. Truly, strictly, legally speaking, our country requires an amendment in the Drugs and Cosmetics Act because all the medical devices are still defined under section 3B4 and there is a regulatory pathway. That regulatory pathway is Constitution of India is on the top. Then comes the act, then comes rules, then comes orders, FAQs or anything, directions, etc., etc. What this regulatory pathway means for us as enforcement agency. Every order passed must have the enabling provision in the act. Rules. Every rule made must have the enabling provision in the act. And every act should have the enabling provision in the Constitution. Law is dynamic. Supreme Court has the power for judicial scrutiny of any act. And Supreme Court falls heavily whenever it finds any act contradicting to the Constitution or finding no enabling provision in the Constitution. Not going out of the context, but just to tell you. Recently, just 1 year back, Supreme Court in these days only declared one act null and void. Again telling that this act has no enabling provision in the Constitution and against the law of transparency and against the right to information. Electoral bond. You all must be aware of this. Therefore, this act also need immediate attention of getting certain amendments at least. But that is not the scenario with you people. But just to tell you that you must follow the provisions of the rules and act, or otherwise this regulatory pathway will decide and declare your action null and void, as done by the Karnataka High Court in the matter of Zim Laboratories. Therefore, while performing your duties, it is a mandate to follow the guidelines issued by DCGI or mandate given in the rules. At the time of seizure videography, independent witnesses, sampling I have already told you, minimum quantity required, sent forthwith, giving opportunity to the person to put his own seal or mark on the sample portions, and not jumping directly to the roof. Complete the process. You can initiate the process of asking for the bills soon after collecting the sample. Who stops you? But without taking the complete ladder in your possession, you cannot go directly to the manufacturer, which we are generally more interested in doing so. Inspection. Again, coming back to this. Any premises wherein any drug or cosmetic is being sold or stocked or exhibited or offered for sale or distributed. Similar type of looking words, but separated with the word or. In law, what is the difference between and or? Most of you must be knowing this. Most of you, 80 to 90%, but still feel 5 to 10% are still ignoring this fact. And means both. Or means either this or this. Sold. Whether sale is there. Or stocked. Whether only stocking is an offense. Yes. Because or is here and stocked is here. Number one. Number two. In many cases, Supreme Court has held that stocked means stocked for sale. You are not required to supposed to prove the sale every time. Now, he has to prove that this is not for sale, but this is for my personal consumption. But for personal consumption, he must have the prescription, and the quantity of drugs should have been very less. And no drug inspector is going to seize the drugs which are in such a small quantity. But as far as narcotic drugs and psychotropic substances, medical intoxicants are concerned, which provision is applicable? How you calculate the quantity, whether you are notified under Narcotic Act, NDPS Act? No, I don't think so. Only Jharkhand drug inspectors are notified. Probably. You people are not notified, I think. You are notified under Narcotic Act. Which section? Please check and then we will discuss. But one thing is very clear. Section 2 and Section 80. Section 2 of Drug Act and Section 80 of the Narcotic Drugs and Psychotropic Substances. Both acts are in addition to each other and not in derogation of each other. And the quantity of narcotic drugs is to be calculated on the basis of, please listen very carefully, on the basis of whole quantity by weight or volume. Where it is given. If you are not notified, then who will do that? Then who will take the action? This is a question which is generally drug inspectors are missing. This whole quantity is to be calculated by the person, police personnel who is seizing under NDPS Act, taking action under NDPS Act, maybe on your request. But he may take your assistance in calculation of that. From where this whole quantity version came? Initially, few of the narcotic drugs in a particular dosage form, in a particular quantity, were declared drugs. Considering and taking that these are out of the purview of the narcotic. But when the misuse of medical intoxicants started, again telling you that law is dynamic, government give a thought to it, then came with another notification in 2007 probably, telling that you have to take the whole quantity into consideration. Whole quantity means CBS cough syrup is there, codeine based cough syrup. You have not to calculate the codeine as declared on the label. You have to take codeine syrup volume in one bottle and total number of bottle and total volume is this. In case of tablets, you have to take the weight into consideration. But not you, that is to be done by the police. Then drug inspectors generally think, since the action is to be taken by the police, why should I do anything? I am not going to take anything. If I take any action, that will come under double jeopardy. Do you think that this is coming under double jeopardy then? You are debarred from taking any action if action is taken by the police under NDPS Act. Can you still take the action under Drugs and Cosmetics Act? Answer is yes. That will not attract the double jeopardy because of Section 2 and Section 80 of the respective acts. And I don't know, in few states courts have taken the cognizance of this. Your state, any court has taken or not, I don't know. But in few states courts have taken. If the drug inspector is the complainant asking the police to come and take action under NDPS Act but not taking any action under Drugs and Cosmetics Act, then courts have asked the question, you were the person who were notified under section 21 of the Drugs and Cosmetics Act. It was obligatory on you to take action under the Drugs and Cosmetics Act. Why you have not taken the action on the Drugs and Cosmetics Act? Please take action as mandated to you under Drugs and Cosmetics Act. Please check the present legal positions of all the drugs which you are considering as medical intoxicants in your state. Few of them are still in the process of being declared. अभी तो रिकमेंडेशन ही गई हैं, वो भी 1 या 2 स्टेट से गई हैं. कुछ अभी साइकोट्रोपिक सब्सटेंसेस में हम उनको नार्कोटिक मान करके ठोके चले जा रहे हैं, किए जा रहे हैं अपना कार्रवाई. फाइनली कोर्ट विल सी टू दैट ना, देन वी विल बी हैविंग नो आंसर. गॉट इट? Samples. Just one thing I want to tell you here. Never collect the sample on the format or form which is there for drugs or medical device on form 17. If you are doing that mistake, all the proceedings are going to be quashed. And the general mistake, surgical dressing is a drug or device? Device. Absorbent cotton wool is a drug or device? Device, no? Late in 2023, the inspectors are collecting the samples of absorbent cotton wool on considering as drug, and then putting the cases in the court also. And very strangely, in few cases, sample was sent to CDL, and again director CDL has also issued the report considering it as a drug. Please take care of these mistakes. These should not happen. Number 1. Number 2, a common mistake which the drug inspectors are doing. Form 18, how we are sending Form 18 memorandum to government analyst. You are sending daily. You have the target for the collection of samples. In the packet of samples, we are sending the Form 18 in the packet of samples. Yes, na? Yes. That is the what the rule 57 says, probably rule 57. देखो, आप ही देखो, आपने यस कहा ना, देखो, टेक इट, मैं फेंक दूं, कैच करेंगे. देखना रूल 57 है, उसी के आसपास ही होगा. प्रोसीजर ऑफ सेंडिंग डिस्पैचिंग सैंपल्स टू द गवर्नमेंट एनालिस्ट सेपरेट है. रजिस्टर्ड पोस्ट एंड पार्सल, उसको फॉर्म 18 को इन ए सेपरेट envelope you have to send it to the government analyst, not in the same parcel in which you are sending the sealed sample portion for analysis. Why? Then you will remember for this particular provision forever. Why? There is again a rule, procedure of government analyst on receipt of the sample. He will first open the envelope, take it out, and Form 18 has the seal impressions with which you have sealed the sample portion or the parcel. He will compare the seal impression and give it in the form 13. The seal impressions were found identical and time हो गया क्या? नहीं फिर सर कर लेंगे चलो मैं 2-4-5 मिनट में करता हूँ ठीक है it's all right. Then in the form 13 the government analyst is writing that the seal impressions were found in identical and seals were found intact. Only after that he will start the analysis, giving it to the secrecy branch, and secrecy branch will give another number, then they will send it to the analyst, then that analyst will analyze the samples and submit it to the government analyst, then the government analyst will issue the test report on form 13. If you are sending it in the parcel itself and not sending it separately, how he will compare? He has opened, then he is not in a position to compare. And the rule says very clearly, separately. The word separately is there. Okay, now the time to lunch break, and we will assemble again after the lunch. You just read it if you want. That is there, na? You have found it. नेवर अफ्रेड कि मैं अलग से बना दूंगी उसके पैसे रजिस्टर्ड पोस्ट के अलग से लगेंगे. अरे रजिस्टर्ड पोस्ट के कितने पैसे लगेंगे? गवर्नमेंट इतने थोड़े पैसे के लिए आपको नॉन कंप्लायंस करने के लिए कभी नहीं कहते, और गवर्नमेंट तो कभी नहीं कहेगी नॉन कंप्लायंस. नेवर से. फोर्थविथ भेजे, सेपरेट भेजे. दिस इज द प्रोसीजर एंड यू हैव टू फॉलो दैट प्रोसीजर. गॉट इट? एवरी पावर is to be used as per the procedure, power under section 22, used as per the procedure given in section 23 for performance of duties and rule 51 and 52. That is the basic of two things at least, SOP for sampling and SOP for little bit, it will make a base for the SOP for prosecutions. And your problem of medical intoxicants in your states that I have discussed. Thank you.
Thank you, sir. আমরা এতক্ষণ ইনভেস্টিগেশন টেকনিক অ্যান্ড লঞ্চিং অফ প্রসিকিউশন এই বিষয়ের উপর আলোচনা শুনলাম. আমরা প্রত্যেকেরই মধ্যপ্রদেশ খিদে পেয়েছে. চলুন আমরা সবাই লাঞ্চে যাই এবং তারপরই আমাদের আরেকজন রিসোর্স পারসন ফ্রম হরিয়ানা প্রদেশ, শ্রী রাজেন্দ্র কুমার হারনা, ফর্মার ডেপুটি ড্রাগস কন্ট্রোলার, স্যারের ডিসকাশন আমরা আফটার লাঞ্চ. থ্যাংক ইউ.